Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamblett Kerrigan. I've been practicing law in New Hampshire for just under 40 years, about 39 years, and in the Commonwealth of Massachusetts for about 29 years. I'm going to be talking today about loaning money to a relative in New Hampshire. So you have a New Hampshire relative and you're considering loaning money to that person. Obviously, take that very seriously because first and foremost, are you planning on collecting it? Are you planning on, if things don't work out, are you going to just forgive it? Are you going to deal with an inheritance? We'll talk about all of that in today's vlog. So first off, when you're thinking about loaning money to a relative, think about, obviously, outside of the legal issue, the relationship change. You're all of a sudden are now going to be a creditor instead of an uncle or a father or a mother to this person. This person is going to be your debtor, and that's going to change the relationship a little bit, some of the dynamics, so be careful about that. There are circumstances upon which you might decide to help somebody out. You might be in a situation where somebody wants to buy their first house and interest rates are really high, and you want to provide a down payment in this situation so that they can, or so that their loan value ratio is better, or maybe you're going to be the full lender on the situation. If you're in a home situation and they're going to be purchasing a home in New Hampshire, first consider the reality is you obviously want to be telling the truth. If there's going to be another lender, you're going to have to disclose whether or not your loan is going to be a loan or it's going to be a gift. And if you say it's going to be a gift and you later on really mean it to be a loan, that you're not representing things accurately to the lender, and that's a problem for you. If you talk to me about that, that could be bang on, don't do it. And also, if there's a souring of the relationship between you and your child, or perhaps even more, your child and their divorcing spouse, you might find out that that divorcing spouse is more than happy to waive out the gift letter that you signed and say, look, that is not a loan, this is a gift. And that happens. I've seen that frequently in litigation. So be careful. Make sure that you're honest throughout with everyone as to whether you have a loan or it's a gift. If you're dealing with a child in regards to that, and you do have a gift that you provide or a loan that you're providing, having them just sign a loan agreement and a promissory note isn't enough. Make sure you get a mortgage. You can get a second mortgage if the first lender is requiring that, and that's not as good as a first mortgage. But in New Hampshire, we just, as the beginning of the year, changed our homestead exemption of $120,000 to $400,000. What's a homestead exemption? Outside of a mortgage, outside of work done on the property, or let's say tax type things, your loan, if you have a claim against the person, comes after they get $400,000 of equity out of the property. So you basically are going to have nothing in most situations. So don't be in a circumstance upon which you're giving a loan and you're thinking, well, they got a nice house here in New Hampshire and that should take care of it. Unless it's a really nice house with well over $400,000 worth of equity in the property. If you have both of the people, it's got to be $550,000 worth of equity. So well over that. Be careful. Don't do it. Actually have a mortgage on the property. It's well worth it, and it's protecting you. You should be, if you're thinking about a lender-credit relationship, you can be a friendly lender. You can have what I call debtor-friendly language in the property, but it still protects the creditor. You might have a low interest rate, by way of example, and that's one of the circumstances upon which you might be dealing with your son. You might actually, or daughter, you might be giving them an opportunity for a much lower interest rate than what they get in banks. And if that's the situation, that's fine. But make sure you cover it. And if you're going to be getting a loan that is for their house, at least make sure you get it on a second mortgage. And if you're loaning money to your brother or your brother-in-law or sister-in-law or somebody like that, first I don't. But if you do it, get a second mortgage on their house, even if it's hardly any equity in the house. If they know that they can't go and sell the house without taking care of you first, you got leverage. You got better leverage of getting paid your debt. Lastly, if you're in a situation where you're thinking about you're not getting paid in this loan, and it's not a real reality that you're getting paid. Amend your estate plan, go to your estate planning attorneys and amend it and take care of that person. You can say that for Sam, who I've provided for him during my life, as part of his inheritance here, I'm forgiving all the debt that he has to me. You can do that provision, or you can forgive part of a debt. You can do whatever you want. You can make that as part of the inheritance itself, and therefore not have a situation where the executor of the estate, maybe his sibling, has to go try to collect that debt from Sam. And you may want to have a discussion with your estate planning attorney as to how to equalize that out, so that if you have 3 children and Sam's already gotten $300,000 of your $1 million estate, you might be saying that $300,000 of loans are forgiven, and the other 2 children are getting the remainder of the estate. I'm attorney Dan Marr at Hamblett Kerrigan at 603-883-5501, 603-883-5501. Happy to answer any questions that you have. Also, you can check out my weekly vlogs at NashuaLaw, all one word.com, so NashuaLaw.com, and check my personal bio, and from there you can get to the YouTube channel, my weekly vlogs by topic. Look forward to working with you if the opportunity arises. Thank you.